Hi friend, welcome to the Company Law Education and Appeal Series. Today we are discussing Hyderabad ROC Adjudication Order for the violation of Section 29 subsection 1 of the Companies Act, where companies violate the provision by issuance or transfer of the security in the demat form. Let's see the facts of the case. Here the company name is the Premier Energies Limited, is having registered office at Telangana. And facts of the case that the company received, company here education officer has received suo motu application filed by the company and other applicant for adjudication of the penalty for the violation of this section. Company has allotted security in the form of equity and convertible securities for raising funds for generate corporate purposes and for expansion of the operation of the company on various date. Here table is the given for the allotment of the shares, and here also a point is mentioned that the details of the share transfer in the physical mode approved by the board of the applicant company and operation default is given in the table. And as per the legal provision of the Companies Act, section 29 subsection 1a provide that in case of such class or classes of the unlisted company as may be prescribed, the securities shall be held or transferred only in dematized form in the manner laid down in the Depositories Act and the regulation made thereunder, and rules 9A rule 2 provide that every unlisted public company making any offer for issue of any securities or buyback of the security or issue of bonus shares or right offer shall ensure that before making such offer, entire holding of the security of a promoter's director and K managerial personnel has been dematized in accordance with the provision of the Depository Act and regulation made thereunder. Pursuant to suo motu application received in this office, this office has issued adjudication hearing notice to the company and director on a scheduled days authorized represented before the adjudicating authority and submitted that there was non-compliance of section 29 subsection 1a read with the rule 9a of the company's prospectus and allotment of security rules, and company has made the offense good completely on the subsequent date dated 19th March 2024 by converting physical share of the promoter into demat as one-time offenses, and finding here here that the company and the other applicant had admitted that non-compliances of this section and made the offences good by converting the physical share of promoter into demat as one-time offense. And in order, having considered the facts and circumstances of the case, and after taking into account the factors and submission made in application and by the authorized representative during the hearing and the facts of the case, it is proved beyond doubt that the company and its officer of the company have defaulted in comply the provision of the section 29 subsection 1a of the Act and made the offence good on subsequent date by converting the physical shares of the promoter into demat as one of this one-time offense. In this regard, the company and officer in default are hereby imposed penalties as under that on the company that Premier Energy Limited, that is 90,000 on default, and here the total penalty 90,000 on officer in default, three officer in default, two officer in default 90,000 each, and one executive director 70,000, and two other on company secretary, two company secretary. Here is the 50,000 and 40,000 respectively, and total penalty here imposed on the company and official default, that is the 4,30,000, and adjudicating officer is opinion that penalty is commensurate with the aforesaid offence committed by the notice, and the notice shall pay the amount penalty on MCA, and proof of same along with this order should be filed in the form INC 28 within the 30 days of receipt of this order with the office of ROC. Any person aggrieved by this order may prefer appeal to RD having jurisdiction in this matter, and file appeal within the 60 days from the date of this order with the copy of this order. Thank you so much for watching this education order reading, and this is the first case of the violation of section 29 subsection 1A in this matter. Thank you so much.